And for the panel?
I thank the chairman of the Rules Committee. We're aware of so many abuses of the FISA 702 program now that we weren't aware of years ago. And I'm sure Chairman John Conyers and Ranking Member Jim Sensenbrenner, when they put this into place in 2008, didn't anticipate the ways that this would be abused. But now that we know it's been abused, even the agencies are telling us that they've abused it. Not once, not twice, not 100 times, not 1,000 times, but 278,000 times it's been found to be abused. And given all of that, and given what we know, I think we would be derelict in our oath of office, where we swear to uphold and defend the Constitution, if we did a clean reauthorization of FISA or anything close to it. We have to address these issues, and we can't take their word for it from the FBI anymore. We promise, we double promise that we will not abuse this again. They've tried to assure us that they have protocols in place. Protocols are not warrants. Our founding fathers got this right when they said that everybody's going to be secure in your place and effects and your personal belongings. Then when they enshrined our privacy in the Constitution and said you have to get a warrant and have probable cause. If the government wants to surveil citizens, those are the things that you have to have. And they've erected this legal scaffolding that I think is some of the shakiest scaffolding I've ever seen, where they say that it's legal. What they're doing is legal right now. But let me summarize what they're doing. They are using the FISA. This is Foreign Intelligence Surveillance Act, not Domestic Intelligence Surveillance Act. It's FISA, Foreign Intelligence Surveillance Act, and they're targeting people who don't have constitutional rights. I'm fine with that. Vladimir Putin doesn't have constitutional rights. Merkel doesn't even have constitutional rights, okay? Not in this country. Now, if she visits, we'll afford her some rights. But anybody who's not a U.S. citizen, who is not inside of the United States, doesn't have those rights. And so we can spy on them. And I'm fine with that. And nobody here is talking about stopping that at all. What we're talking about is a program that right now was designed to target foreigners. It is targeting foreigners, but it is harvesting massive amounts of data, and incidentally collects our information, our communications, members of Congress, donors to members of Congress, just regular constituents who get up and go to work. They get swept up in this. And what they're saying now with this legal scaffolding is because we collected it legally, we can legally go in there without a warrant and search for Americans. There's a problem with that. Yes, Mr. Nadler?
Yeah, I agree with you.
Turn your microphone.
It is on.
Okay.
I agree with you completely, and I simply want to say, the bill before us is totally inadequate. You're going to hear, after Jim and I leave, you're going to hear from the Intel Committee. They're going to tell you exactly the opposite. Yeah. The Judiciary Committee has proposed 3 amendments. The warrant requirement, the data broker amendment, and the about collection. Yep. I've spoken about it, though. If those amendments are adopted, it's a good bill. It protects, it allows for the proper collection of intelligence. It protects Americans' civil liberties. The Intel, and I hope the committee makes those amendments in order. The Intel Committee has 3 amendments that go in the opposite direction. One already expands the definition of foreign intelligence. One subjects new business to surveillance under Section 702, and one drags immigration into the debate by turning Section 702 on anyone who crosses our borders. Those 3 amendments go in the wrong direction. If they are adopted, we may not be able to support the bill. We certainly can't support the bill without the warrant, but even with the warrant, if some of these amendments are adopted, they call the bill into question. I hope the committee will make the 3 Judiciary Committee amendments in order, and the 3 Intel Committee amendments that I just mentioned not in order, so we can improve the bill on the floor tomorrow. have a better odds of improving the bill on the floor and being able to pass a bill that does what we need to do for intelligence and protects our civil liberties. And I
Well,
thank you for your-
this is a rare occurrence, and I hope it's not too common, but I find nothing to disagree with in your testimony. Mr. Jordan, Chairman Jordan, can you go through what those 3 amendments, 3 or 4 amendments, I don't know how many judiciary is offering, and I know we're going to hear from those sponsors later, but can you just briefly summarize what those are and why they're important?
We got the warrant requirement, probable cause warrant requirement. We have the Fourth Amendment's not for sale, which is in essence a warrant-like issue because it says the federal government can't go purchase data that would otherwise require a warrant to get. And then we get rid of about collection, which is if people that are being targeted, they talk about someone, you can't collect that information. That hasn't been in operation for 7 years. We just want to say if you haven't done it for 7 years, you should end it. So those are the 3 key amendments that we have coming forward that we think help. But I would just point out, you're exactly right, Congressman. Protocols and process by the executive branch do not equal a warrant by a separate and equal branch. That's why we have our system. We're literally talking about the fundamentals here. And then when you put in what we've learned, as you pointed out, since 2008, where there are hundreds and hundreds of thousands of targets our government has that they're surveilling. Those people talk to all kinds, some of them are just like diplomats from friendly, like you mentioned Merkel or the assistant who works for Merkel, those kind of things. They're collecting all kinds of communications, and guess how many times they searched that communication data on U.S. persons in 2021? They said, here's the estimate we got from the Justice Department. Estimate, 3,394,053. That's how many times they searched this giant haystack of information that they're collecting on Americans. And all we're saying is if you're going to do that on an American, go get a warrant, which the ranking member rightly pointed out happens every stinking day in this country. Every day law enforcement gets warrants. That's all we're saying. That's the protection. And oh, by the way, if there's an emergency exigent circumstance, you don't have to get the warrant. Or if you go to the person and say, we think you're being targeted by a foreign government, will you give us your consent? You can give your consent. Or if they know it's some kind of malware that they know a distinctive cybersecurity threat, the malware, they can say, we can go. That's an exception. I don't know how better we could write the amendment than that. But that's how and to Ms. Scanlon's point, I argued for bringing our bill up. We're the committee of jurisdiction. Bring the bill that came out 35-2, put that on the floor, and let you guys on the Rules Committee make and order the amendments that the Intelligence Committee wanted to change things. That's how the process is supposed to work. We argued for the normal process. But our leadership decided, no, they want to do it this way. Okay, fine. Then let's make sure our amendments get in order. More importantly, let's hope our amendments pass tomorrow on the floor.
Now, you mentioned there were 3.3 million searches using American person identifiers. How many of those were done, according to the FBI's own protocols, wrongly?
278,000.
278,000. And what kind of things were they searching for when they went in there 278,000 times out of 3 million?
It could have been a violation of some process. It could have been, you didn't check this box, you didn't do that. It could have been a variety of reasons why it didn't comply with the rules the FBI put in themselves. I think the more fundamental point is they didn't follow their own rules. And so that's why I said at the outset of my testimony, that's why I think it's not just good enough to say, oh, we have better rules for them to follow. Well, you can have the best rules in place, but if they already demonstrated that they won't follow them, that's not enough. It's why you need a warrant.
And how many people do we think are able to search this database?
Well,
domestically. I'm not talking about CIA, NSA, FBI, DOJ.
Well, we were in a briefing, and it wasn't a classified briefing, where they told us it could be upwards of 10,000. Now, the underlying legislation, which again has some good reforms in it, limits that number dramatically. We think it's now down below 1,000, but it's still a relatively big number. But it's much better than what it was, what it'll be,
But thousands of chances for somebody to basically violate the Constitution, and you got to have another branch of government watching over this. You can't have the same branch watching itself.
That's why you need the warrant.
That's why you need the warrant, exactly. Let me talk a little bit about the process, because I'm disappointed in it too. I'm a believer in a good process, and I went back and looked, and it was actually Chairman John Conyers and Ranking Member Jen Sensenbrenner, who put FISA 702 into place in 2008. It was their bill, and they managed it on the floor. And, Judiciary created a very good product that has the warrant in it, has provision to keep the government from buying information they would otherwise need a warrant for, has a lot of other good safeguards in it. In my opinion, that should have been the bill that was on the floor. We could have an open process here. Intel could offer as many amendments as they want. And by the way, I don't want to downplay, they do have some jurisdiction in there in the FISA bill, but it's the outward focused portion of it, not the part of it that's been turned on American citizens. Like when we're talking about who has jurisdiction over what, we're not in judiciary claiming that we need to oversee the CIA and what they're doing overseas. And Intel should not be, trying to say that they have authority or jurisdiction over when you need a warrant to spy on an American who's living in America, using information that somebody else has collected, that not domestically, not with a warrant. I mean, that's one of the other fallacies. They say they collected all of this information legally. Yes, that is true. But you didn't collect it with a warrant because you were surveilling foreigners. So you can't then take that giant haystack, as you said, and it's enormous. Yep. I don't think people have an appreciation for how much data is there and how much of your private information is contained in this haystack. And Ms. Sparks has mentioned earlier, too, that we don't even know about their minimization procedures. Okay, let's say you want to target somebody in Afghanistan, okay? Well, maybe there's only one ISP in Afghanistan, and you can get all of the emails that come in and out of Afghanistan. How do we know that if you're emailed it and go through there or copy somebody in Afghanistan, that you're not in that giant haystack? How do we know that they're minimizing this data that they're trying to collect on what they say are legitimate targets? I don't know that we know. But okay, so we got this process. It should have been the judiciary bill. It's not the judiciary bill. It probably tracks closer to the Intel bill, the base text. There are some provisions in here that we can all agree are probably good things. But if you remember the Judiciary Committee, you know this does not go far enough. We had an open and robust debate for hours when we marked up our bill, and ultimately included the warrant provision. Ultimately included Mr. Davidson's, the Fourth Amendment is not for sale. Ultimately included a lot of other stuff that should have been in the base bill. But what we got now is a different base text, and we're going to hear a good debate over this. And then we're going to have some votes on these amendments. And that's the good thing about this process, Mr. Chairman, is that we do have a rule here that we don't know what the rule's going to be yet. I'm kind of waiting myself to see the final form and to make sure that what we've talked about is what becomes. But we're going to have a process here where every member of Congress who's present, and I think we had, how many voted last night? Maybe 430. Every one of those is going to be here this week. And they stand in front of God and country and their constituents, and they're going to be taking votes on whether they think you need a warrant to go get this information. Yes, Mr. Chairman.
If I could, Congressman Massie, and I think that will be the first time that the House of Representatives will have an opportunity to go on record for requiring a warrant for the 702 program. So that is why that amendment is critical, that it be made in order, and let's hope it wins. But there's a chance for, in front of God and everybody, the American people can say, who in the United States Congress believes that you should get a warrant if you're going to go look at Americans' information?
So it's interesting you bring up the statistic. Is this the first time we've had a vote on whether you should get a warrant or not? We've had similar votes. Ms. Lofgren and I have sponsored these in the appropriations process. But what we were told in that process is, this is not the proper time and place to bring up the warrant in the appropriations process. That, these limitation amendments, they've got parliamentary restrictions, they're blunt instruments, and if you want to legislate this properly, you need to do it in the Judiciary Committee. So I got on the Judiciary Committee. And then we got to do this. And we got a great bill, and we bring it to the floor, and we're told, no, we're going to substitute it with something else. But we'll give you a fair shake at this with some amendments downstream, which we're okay with that. We need to win the argument in the debate. But to your point, Mr. Jordan, we've had some proxy votes. We've had some approximations of what we're going to do this week. But they always said, wait for this moment. Wait for the reauthorization of FISA. And that is the proper time and opportunity to include this warrant provision. Yep. Now, I would argue that we've been in a constitutional crisis for quite some time, and that the right time was immediately. But here we are, just as Congress often does, we don't do much of anything until something expires. And nobody's talking about wanting to let this expire. Nobody's saying this is a tool that we should deprive our outwardly focused intelligence agencies who try to keep this country safe from foreigners. What we're saying is it's been abused. It's been turned, the same tools that we use on Russians and Chinese and Iranians, we're using on our own people. The same database, we're going in there and we're fishing for Americans' information in violation of the Constitution, and that's wrong. So I think I'm glad to see this is coming to the floor, assuming this rule is made in order and it's a good rule and it passes on the floor. I'm glad to see we're having this debate. I'm glad to see that finally people aren't saying, well, wait 6 years and we'll address this in 6 years. Well, some people are. Some people are saying there's nothing wrong with it right now. In stark contrast to the reports that we get from the IGs, the Inspector Generals, from the DOJ, the FBI, that this thing has been abused. So I hope we do, Mr. Chairman, I hope we do make these amendments in order that give everybody a fair shake at voting on these issues that have for way too long. I've been here, not as long as you, Mr. Nadler or Mr. Jordan, but I've been here almost 12 years now. And they keep saying, wait your turn. This is the time. I believe we're going to put a rule in place that gives us a robust debate and lets us have this vote. And hopefully we carry the day. But I agree with the ranking member of Judiciary and the chairman of Judiciary that this bill, without amendments, does not go far enough. In the most consequential flaw in the reauthorization is the lack of requiring a warrant to go into that database and spy on Americans using information that's already been collected on foreigners. So with that, I hope we make these amendments in order. I hope everybody gets a good debate on it, and I hope that the ones that the chairman and the ranking member of Judiciary support will pass and become part of the underlying bill so that I can support it. But I will say that it's not supportable in its current form. And with that, I yield back, Mr. Chairman.
Thank you, gentlemen. As the gentleman knows, we've